Legal maneuvering begins much earlier than the trial itself. Lawyers frequently file arguments or motions to the judge in almost every case. During the deposition, your own attorney will occasionally object to a question. A greatly important tactic is that you should stop talking if your retaining attorney makes any objection. This objection must be recorded before you answer the question. In addition, you may not want to answer the question after you hear the objection and any related guidance to you about answering the question or not. If your attorney directs you not to answer a question, do not answer it, even if the other attorney argues with your attorney or attempts to convince you directly that you should or have to answer the question. The attorneys can always resolve your lack of a response later. However, if you answer the question when you should not have, nothing can undo the harm possibly caused by inappropriately giving information away. So you should get into the habit during a deposition of pausing for 1 to 2 seconds before answering any question. This pause helps your attorney because it gives him the time and the opportunity to object if he likes. Appreciating legal issues can help you to more significantly help your attorney in another way. Sometimes, either because of your own conflicting work schedule or your own health, you may not be able to attend the trial for which you have been preparing for many months or even years. The burden might then fall to your retaining attorney to convince the judge that your deposition testimony should be admissible. Admissibility is a complicated legal arena. To help your attorney, and because of the increasing importance of Dober criteria, it becomes crucial that you make the effort to incorporate information about both relevance and reliability into your deposition testimony. The key criteria, known to some attorneys by the acronym PEAT, P-E-A-T, are important enough to repeat here for you. First, P. Can you cite any peer-reviewed publications in which the methodology you selected has appeared? 2. E. Does the methodology have any known error rates? 3. A. Is the methodology generally accepted in your field? And finally, T. Can you replicate the results if you repeat the testing? Answers to these PEAT questions will help, but in the scientists' terminology, they are neither necessary nor sufficient. The Dober case and follow-on cases have helped to define admissibility of expert witness testimony. Your testimony must convince the court that your opinions flow logically from the findings based on your chosen methodologies. This could involve additional considerations, such as whether the data used in your investigations and analyses was both qualitatively and quantitatively sufficient to justify your final opinions. When you express your opinions in deposition, you make clear that you used reliable methodologies to reach those opinions. Your testimony must also make clear that your methodologies and approach to your investigations are generally accepted in your particular field.